An EMI share scheme is an enterprise management incentive scheme, and these are tax-efficient share schemes designed for small, medium-sized enterprises. The company concerned can't have gross assets of more than £30 million, and each employee option holder can't be granted options worth more than £120,000 at grant. And for most small, medium-sized enterprises, those limits cause no problem, and it does provide a simple, tax-efficient means of incentivising employees. The tax position with EMI options is that the employee pays tax at 18%, that's capital gains tax, when he sells the shares. It doesn't have any tax to pay when he's granted the option or when he acquires the shares, it's only when he sells the shares. That should be contrasted with an unapproved share option scheme, where the employee can end up paying tax when he acquires the shares, not just when he sells them, and the tax can be at rates of up to 41% for the individual, and in addition the company can have tax of 12.8% to pay. That's employer's national insurance contribution. That means an effective tax rate of 46.5% after tax relief on the employer's NIC. So quite a difference between the 18% and the 46.5%. Owner-managers who are considering granting EMI options first of all need to decide what rewards they want the employees to obtain in 5 or 10 years' time when the company's sold. They then have to calculate the number of shares that will achieve that value based on certain growth projections for the company. And they need to sit with experienced advisors who can help them work out those financial criteria. There are two types of EMI share option scheme. There's what's called an exit-based scheme, and then there's an ordinary EMI scheme. The key feature of the exit-based EMI option is that the employee doesn't obtain any share until the point at which the company is sold. With an ordinary EMI option, the employee acquires the share some time before the company is sold. Now, that means it's much simpler to structure an exit-based scheme because you're not concerned about the relationship between the employee shareholder and the founders of the company. A company that's decided it wants an EMI option and those options are not going to be exit-based, the key questions that then arise are these. You've got an employee who's going to become a shareholder. What happens if that employee leaves? You almost certainly want to have the right to buy those shares back, probably at fair value. The other key question that arises is what happens when the founder shareholders want to sell the company? Can they insist that the employee shareholder sells at the same price? So again, almost certainly what you want to include in the Articles of Association of the company is what's called a drag-along article, so that you can insist that the employee shareholders sell at the time and at the price that the founders want to sell. The typical cost for an EMI share scheme, if you're going for an exit-based one, would be £2,500 for Everyman legal's costs, and you probably need to budget on £500 or so for the accountancy costs on the valuation.